everybody. Excited for you to be here for the Ethy Awards. This is an award show. Hopefully you've gotten your Versace and all your fancy runway clothing, because this is going to be, you're the audience of an award show. I do this every year, and this is the 2023 version where we pay homage, tribute to the best of the worst of legal ethics violations over the last year. So the things we're talking about are cases from 2000 last year where lawyers got in trouble. Now, the way this works is we do this like the Academy Awards. We have categories, and then we have movies that represent the nominees, and then we'll talk about each case as it goes along. All right, that said, our first nominee, our first category is the Outlawyer Award. Now, we give this award every year to lawyers who forget that a very important part of the word lawyer is that first part, the law. And that lawyers tend to forget that it's very difficult to be a lawyer and lawless. That doesn't work from a definitional standpoint. It certainly doesn't work from an ethical standpoint. The rule we're talking about is Rule 8.4B. Now, I believe this might be on the screen here, the ABA model rules. New York, your rules, you've adopted the ABA model rules. In almost every respect, your rules are exactly the same. I think there might be a couple of differences. We'll talk about it in other areas, but I mean, it's just wording differences. But every state has a requirement that to be a lawyer, you have to follow the law. What a concept. Now, the thing that's interesting is that that's obvious. And if you were to commit a major felony, 8.4B is the least of your problems. Right? Prison will be a bigger problem for you. However, I'm going to show you here that you don't have to commit a major felony to have a serious problem with your law license. As it turns out, the bar will actually sometimes be a lot more stringent than the criminal courts. And so you might get a slap on the wrist in the courts and slap somewhere else if you from the bar. And the bar want to hurt more sometimes. The interesting thing to understand here is that when you look at the commentary for that rule, the ABA commentary, you'll notice that this is a pattern of offenses, even ones of minor significance when considered separately, can indicate indifference to legal obligation. And here's the important part, is that it's not just, like I said, following the big ones, but even rules of minor significance, when considered separately, can bite you in the tuchus. All right, that said, let's get right to our first nominee. This is the movie I Care a Lot. And it's a story of a lawyer who was defrauding her Medicare and Medicaid clients, stealing all of their funds. And this one is similar. Here we have a Maryland lawyer who's been suspended because she got caught engaging in Medicare fraud. Now, by the way, this fraud that she engaged in was even prior to her getting her law license. While she was in law school, the way she earned money was that she was a home health care worker for someone. They charged the Medicare, Medicaid, she'd stay with these people and care for them. Well, she wrote on a paper that she was doing that. It turns out that a lot of the hours where she was supposed to be providing care, she was actually at the law school, right? Or other places, Starbucks, et cetera. We know about the law school specifically because she had to sign in and out key card access with the law school. And those times matched up with the times she was supposed to be caring a lot for these other people. I don't know how to explain this to you, but you can't do that. Now, the thing I find interesting about this case, though, is that this is a lawyer who ends up being suspended from the practice of law for activity that had nothing to do with not only her law practice, but not even when she was a lawyer. And the fact that in the past this happened, there's statute of limitations for criminal purposes, but almost never for bar purposes. So even though this happened well before she was a lawyer, it's going to cost. She's going to spend a lot of time driving Uber. Her excuse will be, well, this happened beforehand, and here's where it's going to come back and bite her. When she was applying for the bar, filling out her moral character exam, they asked a question: have you committed a criminal act? When they ask that, they don't mean, did you get caught and have we caught you yet? It means, have you done it? And if it turns out later you've done it, but we didn't know you've done it yet, you still going to have to get done it. All right? Bad grammar, good legal ethics. Move on to our next nominee. The movie The Postman rings twice, always rings twice. Not even sometimes. Postman always rings twice. I understand in the movie, there was a character, I guess the Jack Nicholson character was extorting someone. This is something that happens similar here. Here we have a lawyer who's been disbarred. Sadly, he's a former general counsel of the Motion Pictures Association. He had some in with the Academy in getting a nomination here, but he meets a woman on a dating site and they get together. And then during the course of the date, they agree to, I'm just reading the terms here, a consensual exchange of sex in exchange for $400 in cash. Now, a couple of things. One, if you're going to do this, and you don't, but if you do, don't be cheap. All right, the guy was making $3 million a year. All right, don't you be being cheap. All right, that's going to cost you. You see here, the guy got disbarred. Secondly, maybe more importantly, and seriously, the thing that the lawyer does here that becomes even more problematic is that after they have this transaction, she was pretty much put off by the whole thing and decided that this is not how she's going to go about life. But he wanted to continue and threatened extortion. If you don't continue this arrangement with me, then I'm going to tell your employer, the Better Business Bureau, your mama. That then comes into effect of criminal extortion. Obviously, this guy has big problems. Sadly, the criminal courts don't really deal that much with that. You're not going to go to jail, sadly, unfortunately, but you will go to bar jail forever. No more practicing law for him. Good. Next nominee here is the movie Rear Window, and here we have a Michigan lawyer who liked to look in people's rear windows, and as a result, he got suspended for 6 months for the crime of window peeping. Now, I didn't even know what this was. I had to do some research for you on this one. But window peeping is a crime whereby it's illegal to sneak onto someone else's property and then look through their windows. Now, if you do it like in the movie Rear Window from your own property, and you just happen to be creepy with a telescope, not recommending it, but that's not the crime this guy's charged with. He's stepping on people's ledges, like looking over the window. The worst part about this is this wasn't his first offense. Right. The reason that I know about this and it got made a big deal is that this was him violating parole on a previous window peeping conviction. And obviously, people, I don't know how to tell you this, but we have the internet. Right? There are people who want you to peep with them, and they will for $4.99 an hour or a minute or whatever. You can do that. The idea that you're going to violate other people's privacy is going to be a bigger problem than you think. It's not going to be one of the things we go, boys will be boys. Boys, get OnlyFans account. All right, that's it. Move on. We're the Millers is our final nominee in this category. And here we have, by the way, the movie We're the Millers involved this all-American looking wonderful family, and then none of these people turned out to be who they look like. Right, they're drug dealers, right, and extortion and scam artists and all the bad things in life. People don't, guys who don't put the toilet seat down. All right, horrible people. In this case, one of them was a drug dealer, and in this case, sure enough, we had an Arkansas lawyer who seemed to be a very respectable person. And when he landed in Arkansas at Little Rock Airport, they thought he was respectable, even though he had quite a bit of luggage with him, like 180 pounds of luggage. And it turns out that the luggage was all filled with pot. Now, this is I had to look on the internet. This isn't from my closet. All right, I looked on the internet to find this. This is 40 pounds of marijuana. Now, imagine 4.5 times that through airport security. People, airport security is kind of lax. They're a little light, but nobody's gonna miss 180 pounds a week. All right, that's ridiculous. You got to send that FedEx, or not at all. That's an even better one. Interestingly enough, the lawyer pleads guilty to just 40 pounds. He says, the other 100, I don't know how the other 140 pounds got there, but this 40 is mine. I'll take that. Obviously, he got a 6-year prison term. Ouch, that hurts. And of course, he has been suspended interimly. He will be disbarred. No more practicing law. The reason that this case struck the Academy's interest is because this is an important issue for lawyers across the country, because as some of you might have heard in the last several years, marijuana has become legal in many jurisdictions. I think the majority now, some form, all right, either outright recreational marijuana, like here in Arizona, or hypothetically, or in places, other places you have medical marijuana, where you go to the doctor and you say, "Doc, my back hurts." And doc says, "How old are you?" And you say, "I'm 50. And they say, "Of course your back hurts. It's called 50. How much weed do you need?" So then between those two, just about everybody gets their weed now, but not everybody. I was just in New Orleans recently, and well, actually they have it there, but in Texas as well. Texas doesn't have no weed. Now, there's weed in Texas, all right, but it's not legal. The reason I mention this is because we're having a problem with lawyers. We have a case almost every year of lawyers who get caught going to a jurisdiction in which you can have marijuana, thinking, fine, relive a little college. You go to the convention in Vegas, you get your goodies, and then you say, wait a minute, I'm going back to Texas. I don't want to be without goodies for the next 365 days. Maybe I'll sneak some goodies back with me. And the answer to that is, say it with me one time, no. It doesn't seem like a big deal. But as a lawyer, remember, you have to follow the law. Okay, and even the laws that don't make sense anymore, even the ones you think are stupid and ruining your fun, you still have to follow them, and you'll be in trouble. All right, just as much as anyone else. All right, more so because you won't be able to earn a living for something silly as that. Now, these are our nominees, and when the Academy tries to pick a winner, and there are no winners, a recipient for the Ethy Award, they're looking for the matter that is not the most outrageous, but the one they think that you, as a reasonable lawyer, might find yourself doing. The difference between these people and us is oftentimes a matter of degree and not kind. And so of these nominees, there's I Care a Lot. Remember, this is the person who was ripping off the Medicare people. The postman always rings twice. The extortion guy. None of us are doing this. You do that, yeah, shame on you. The rear window, the peeping person, man, that's kind of pathetic too. Or you're going to get caught you're trying to sneak your edibles back to Alabama. And the answer, of course, is, drum roll, I Care a Lot. This Medicare fraud. Because here's the thing I found out is that very few lawyers I've ever met would steal money outright, or just grab someone's, just snatch someone's chain down the streets in Manhattan, right? Nobody, none of us run that fast. You're not going to do that. But this idea of overbilling and charging, it's the government, especially who wouldn't, it's the government, right? That's not really stealing, right? Yeah, it is. And every year we have cases of lawyers. A couple of years ago, we had a lawyer who was still, after years, was still on his ex-girlfriend's health insurance. She had some partner benefits. They were no longer partners, but she, didn't tell the company. He didn't tell the company. He's using her health insurance. He's thinking it's no big deal. It's just, it's $800 a month in premiums, et cetera. I'm just ripping them off a little bit. It's an insurance company. Who cares? The bar cares. And how much does the bar care? They care a lot. See how I tied it in there? That was what makes me a pro, people. Let's move on. Most creative billing. So I had a question here, and let me just, before we get to this next category, about medical marijuana or marijuana. And the idea, and the question is, how do you deal with a situation where marijuana is legal in your state, but still a controlled substance for federal law? How can you counsel a client about setting up a marijuana business? That's a good question that I am not smart enough to know the answer to. But I have seen, because I'm in this business of CLE, that there are actually courses. And I bet you that there's one that deals with this question specifically about how you counsel them to do that. I tell you, there was an ABA opinion. Actually, as a matter of fact, no, not ABA. There's a New York State Bar opinion that says that you can counsel someone, the ethical rule that says that you can't counsel a client to do things that are illegal. We'll talk about that later, but it's Rule 1.2D. That ethical rule does not apply, all right, to legal marijuana in New York. It is not considered illegal because it is a state, all right, it's permissible by state law. I know there's some conflict with federal law, but there's an opinion, I believe it's in New York, that says you're good. So go ahead and do the counseling. All right, that's it, let's move on. The second category was most creative billing. The rule that really is in effect here is Rule 1.5, fees and expenses. A lawyer should not make an agreement for a charge or collect an unreasonable fee or an unreasonable amount of expenses. Let's talk about lawyers who charge unreasonable fees. The first nominee here is the movie Double Take. And certainly doing a double take on fees is always going to be considered unreasonable, like trying to get twice as much as you're entitled to. Here we had a case of an Illinois lawyer. He's a partner in a big mega firm. I'm not naming the firm. They have lots of lawyers. I'm pretty sure they're good at suing people. It's why they're a mega firm, but it's a firm we'd all know. One of the partners has a client that's a financial institution. And the financial institution has an agreement with its customers that if lending this money to you requires us to hire a lawyer and do legal work, you're going to pay for that work. And so there's an arrangement that allows the lawyer to bill directly the bank's client. The lawyer does that, and somehow bill also goes out, I'm assuming inadvertently, to the client, the bank themselves. And guess what? Both parties pay the bill. And rather than returning one of the checks, the lawyer thinks, hey, I'm about to double my billing up in here. All right, I'm about to get to the corner office. And so he does not tell anybody and continues collecting checks from both parties. Now, it turns out in large law, in large law terms, this isn't a lot of money. Just $100,000 of extra billings. I don't think they get you to the corner office, right, at the big firm. But it does get you a 3-year suspension when you get caught doing this. And interestingly enough, one of the things that's I find interesting about this case is that my guess, I didn't talk to the person, don't know, but my guess is that wasn't their original idea. They got 2 checks and they thought, hey, you know what? This is a tip for how good I did. I did such a good job. I really should get double my fee. And you know what? And it's amazing the kind of things you can talk yourself into and then talk yourself out of 3 years of practicing law. And I promise you the $109,000 isn't going to take care of 3 years. All right, and not being able to practice law, not even close. Our next nominee here is the movie Illegal Tender. And one of the things that is both illegal and unethical is to require some tender in exchange for your legal fees. And I mean some tenderness, some sex. We have a lawyer here who was bartering, right, sex for legal services. He would approach vulnerable women with no money, that's I'll represent you, in exchange for tenderness. That's not only illegal, it's creepy. In every respect, it's wrong. It's exploitative. I'm not sure why you think that'll work. This is a good reminder as to why you want written fee agreements. See, written fee agreements will prevent you from doing something this dumb, because no one's going to ever write that out or have someone sign that. That might stop you. It might not if you're that wrong, but you get the point. Our next nominee here is a movie, A Price Above Rubies. And here we have a Louisiana lawyer who really tried to charge a price above rubies for work that wasn't that hard. As a result, he ends up getting suspended for 18 months for overbilling the client. The client comes to him and says, look, I set up this trust, a special needs trust, by the way, for my disabled grandchild. And we just want to change the trustee. We have one trustee, but we want to get a different one. And to do that, I don't know if any of you do trust in the states. Maybe probably several of you do. And so you know how hard this is. You have to go to the Supreme Court of the U.S. You have to argue before the justices. You have to go through several hundred pages of forms. Oh, no, I'm sorry. No, that's not what you do. I'm sorry. I'm thinking of something else. Here's what you do to change the trustee. It's a one-page form. You can get it at Kinko's. He charges a client $100,000 to change and alter this form. And turns out that Louisiana says that's about a 900, I'd say 99,000 too much. No, or sorry, 99,000 too much. It's interesting because what if the trust was like for billions of dollars? Certainly, as a percentage level, 100,000 is nothing, right? That's not how our fees work. We don't get the idea of simply saying, well, these are big rich people anyway, and this person doesn't understand. If they're rich, they can pay me whatever they want. That's for almost everything else in a free market society. Certainly for speakers, thank you very much. You can pay me as much as you want, anytime. No ethical problems at all on my part. But as lawyers, no, that's not the rule we get to work by. And the fact that someone is willing to pay it, the old free market rule of a fee is reasonable if you get some fool to pay it works everywhere but the law. Sorry. And then lastly, the movie Trading Favors. Here we have a lawyer who decided they would barter with a client. They had an existing client. The client had been with the lawyer for a long time and been a good client, good relationship. The client comes to him, has a problem, but doesn't currently have any cash. And so the lawyer says, look, okay, I still want to represent you and help you out here. I usually charge you $250 an hour. You don't have the money now, so here's what we're going to do. Make sure that you can pay me back in the future. You're going to transfer title to this 2009 Audi to me. By the way, it's a 2009. All right, what's it worth? $75? All right, and I need a $20,000 mortgage on some real estate you own, and I need you to agree to do some excavation services for me. You have this excavation company. I'll need some stuff on my, I want to have a jacuzzi in the back. And so I don't know exactly what I'm going to want. So just agree, when I call you, you'll come on over and dig a little hole in the backyard. Cool. And that arrangement turned out not to be so cool. Now, there is no rule that says you have to charge cash, all right, for your services. You could literally charge people, right now you could say, hey, I'll represent you, do this real estate closing for you for a carton of eggs, which by the way, actually that might be that might be too expensive. You might not be able to get away with a whole carton of eggs. But generally speaking, what you need is something that does have a discernible value. Carton of eggs does, about $3 million, all right? But at least we know what a carton of eggs costs. The problem this lawyer had is that he got these liens or the title. When you get title to the Audi, that's actually his car. Now it's all of it. And it's hard to say, I get all of this car in exchange for legal work that I'm going to do for you in the future that may or may not. How do you put the Audi in a trust account? When you only earned $400 of it, how do you give them the Audi back less $400? Right? How do you know what I mean? Do you just pull the steering wheel off and give the rest of the car back? The problem with this arrangement is if you are going to have an arrangement for anything other than money or cash, then it needs to be of some discernible value so everyone knows we can judge how reasonable your fee is. It's hard to judge how reasonable your fee is if they've given you, some amorphous promise of, you hook me up in the future. And as a result, it's just a reminder. In this case, the lawyer's motive isn't bad. He's not trying to rip the person off. So he just gets a reprimand like, look, you know what? Don't be so sloppy. But otherwise, it could be a problem. Before we move on, someone asked, what is now a reasonable fee? I've seen information about lawyers getting $4,000 an hour. Is this ethical, legal? And the answer is, it depends, as always. The factors, there's an 8-point factor test in Rule 1.5. And here's the thing about that 8-point test. There are 8 determining factors as to whether a fee is reasonable. It's not like, okay, if you get 5 of these, you're good. Or if you get 2 from one category and 3 from another. It's a very amorphous thing. 1 alone could do it, or 7 might not do it if 8 is too egregious. All right. But one of the factors, all right, is and you real estate people will appreciate this, right? Not only is all real estate local, but also all ethics is local, at least with regard to fees. And so as a result, the fee in New York City, all right, the reasonable fee there is different than the one in Buffalo, all right, or Kentucky, or here in Arizona. In Arizona, we can't quite charge $4,000 an hour yet. In New York, you probably can charge $4,000 a minute. All right, it really depends on what's the going rate in your area. All right, let's move on. So that said, here are our nominees. And the winner, remember, no winner, the recipient, the one that the, I'm sorry about that. Hold on one second. All righty. The one that the Academy thinks the one you're most likely to do, mistake you're most likely to make, is price above rubies. Here is why. Because it's very, this idea of how reasonable a fee, you just saw here, right? We just talked about it a minute ago. It is amorphous. It really is difficult to know. You have to, make some adjustments and market value in the area, et cetera. But what happens, and what's increasingly happened, is there've been a couple cases in which lawyers have got in trouble for charging their legal fee, $1,000 an hour, right, New York City, for things that don't seem to be the hardest parts of practicing law. So the lawyer says, and we have a couple cases of a lawyer who, we'll give you the most egregious case maybe. We had a lawyer in Boston, and the client said, "Hey, can you watch my dog this weekend?" The lawyer said, "Fine," and charged him his normal $275 an hour fee. That's a lot of money for dog watching. If dog watching pays that well, we're all in the wrong business. Now, interestingly enough, it's kind of interesting because I'm sure there's a celebrity dog watcher out there who charges 10 times that, and that's fine because they don't have to keep a law degree or law license. But for us, it matters. And if you are, using if your legal fee is a basis for everything, which is what we always do, it could be a problem. I'm gonna tell you, I'm gonna see a case in the future. It hasn't happened yet, but I'm predicting when you see it, you can think of me, that there's going to be a case in the future where a lawyer gets brought up before the bar on charges of charging $1,000 an hour to fly on a plane. And they're going to say, "Yep, I understand that's your hourly rate, but everything you do shouldn't be equally valuable. And the fact that you charge $1,000 to write a Supreme Court brief and the same $1,000 to sit on Southwest Airlines is wrong. Because to sit on Southwest Airlines, you deserve $8,000 an hour, whatever it is." Okay, but I can see the case that at some point we might have to start bifurcating fees. All right, that said, here is a code that you're going to need for your CLE. This is initialization, ILS CLE, ILS CLE, I love Sean CLE. Should be easy to remember, something that you certainly feel by now in your heart and soul. ILS CLE, I love Sean CLE. That's the first code. I'll give you the second one later. All right, people. Next category here, the David Copperfield Award. You know what? Because I know this, I've done this before. I'm gonna put the code back up and give you a good 10 seconds. Those of you who need to write it down, come back from Facebook, whatever you're doing. All right, if you're on Facebook, say hi to everybody for me. I'll see you guys there in an hour. All right. Here is our next category. And just so we're clear, I did not say it was improper to charge for travel time on a case. I'm not even saying that you can't charge someone $1,000 an hour to sit on a plane, because that's the current practice. I am suggesting in the future, someone's going to suggest that probably $1,000 an hour is too much to sit on a plane, and that a reasonable fee will require to be bifurcated so that you have a travel rate, you have a a filing rate. You've got I'm just sitting here filling in the form rate. I'm doing rocket surgery, the legal equivalent of it rate. Anyway, all right. Let's move on. The David Copperfield Award. We give this award every year to lawyers who have the magical ability to make client funds disappear. The nominees, and by the way, the rule we're talking about here, you see on your screen here, rule 1.15, all right, safekeeping property. This is the rule that says you can't steal the money. The fact that we have a rule for this should indicate how important this is. There could be people who forgot this rule. Let's talk about them. First nominee here is the movie 600 Miles. Now, here is a lawyer who, and when we choose, the Academy chooses movies, they try to figure out plots and themes, or sometimes we just take the title And we like the title here of 600 miles because we have a lawyer here who had almost 600 individual transgressions, 575 of them to be precise. And what I mean by that is that this lawyer was a partner in a firm. The clients paid over checks, 575 checks, of which the lawyer took those checks and endorsed them and deposited them in his own personal account. So he stole $165,000 from his law partners. Now, interestingly enough, is I'm sure the lawyer thought that in doing so, he was actually he wasn't doing anything that bad. See, we'd all know if you stole the client's money outright, that'd be wrong. You'd expect to lose your license. This lawyer is probably surprised to be disbarred because I'm sure he thought of himself as Robin Hood. All right, he's stealing from lawyers, rich lawyers, partners in firms. It's Robin Hood. He's stealing from the rich to give to the upper middle class. All right, that's not really stealing, right? Yeah, even stealing from people richer than you will still be a problem, even if they're your boss and even if they're lawyers. And I understand why lawyers think they can get away with this. Because if you were to steal from lawyers and be tried by a jury of lay people, you would probably get acquitted. They'd probably give you a piggyback ride out of the courtroom and a high five. Everybody would be happy that you stole from the lawyers. Good for you. The problem is your jury, the people who evaluate you and whether you get to keep your law license. What do you think they do in their day jobs? Yeah, they're not only they're lawyers, guess what? They're partners in law firms. They don't let first-year associates on the ethics committee. And as a result, the people who are most sympathetic to the plight of poor, rich lawyers are the people who will decide your fate. As it turns out, believe it or not, you'd been better off stealing from orphans. All right, you'd be wrong. You'd have to answer to your deity for that. But you'd probably get less time. It's never going to work well for you stealing from other lawyers. The devil's due. Here, our nominee is a Georgia lawyer who was disbarred for the heinous crime of paying for his bar dues with a check that was drawn on his trust account. Now, this is a crime. This is interesting because I mentioned he got disbarred. We're not talking about great embezzlement here. We're talking about a trust account violation. We go back and take a look at the rules. You see that the rule says the very first part, the most important part, by the way, the lawyer should hold property of clients or persons in the lawyer's possession. Basically, it says a lawyer shall hold their property separate from the client's property. All right, can't put your peanut butter in their chocolate. And this lawyer did that. He used their money, that's the trust account funds, right, to pay for his bar dues. Now, the thing that's amazing here is that if you're going to write a check, all right, on the client trust account, the last people you think you do with the bar, right? And this is more of a symptom, right, than the actual cause of the problem, in the sense that you don't write your first check, personal check, out of the client trust account to the bar. That's your 7,000th check. The reason this lawyer is disbarred is because this is not the only time he's commingled funds. He's been sloppy all along. The interesting thing is that there's no allegation here that he was stealing tons and tons of money from clients, but he was simply having disregard for the trust accounting rules. If he needs $25, they go to the ATM and pull it out right from the client trust account. And then, so when they do the audit, they say, wait a minute, right? No part of this is right. Now, disbarment seems a little heavy here, but one of the things that, that work for disbarment here is that the lawyer didn't respond to the bar and didn't come to the meeting, right? Cry, tell them, I'm sorry, I was wrong. That might have gotten him a suspension and not disbarment. But if you don't show up to take your medicine, the medicine you can get is going to be, how do I say this? It's not going to be children friendly. It's not going to be, strawberry flavor. It's going to be castor oil. All right? It's going to be some tough medicine, because part of showing you're contrite and upset is that you must, of course, respond. At least say, hey, all right, I'm here. I'm wrong, y'all. If you ignore it, act like they're annoying you, you got better things to do than answer to your silly inquiries. You're gonna, you hope you get, how to say this? You're gonna drive a lot of Uber. Here's the movie Knives Out. If you've ever seen the movie, by the way, a great movie. If you haven't, I think it's on Amazon now. Both that and the sequel, Glass Onion, get them both. But that's my little tip for you. But anyway, this is a movie about people trying to accept an inheritance. And here we have a classic case of a lawyer who violates this rule. We have a Virginia lawyer who has the client leave most of their $1.7 million estate to the lawyer, not the family, the lawyer. Just for those of you who haven't been paying attention at all, you can't do that. I want you to take a look here at Rule 1.8C, and I want you to take a look at it because of its specificity. And understand that when the people were drafting the ABA model rules, nobody sat around looking for hypothetical situations that could happen and said, hey, we need to have a specific rule about this thing that has never happened in this universe. That's not how you draft rules. This is the kind of rule that you draft because it happens every Tuesday. And you say, okay, we need a rule. And then you'll see, because of how this rule is written, just how many times they had to go back and trying to close the loopholes. So you see here, it says that a lawyer should not solicit a substantial gift from a client, including a testamentary gift, or prepare on behalf of a client an instrument given the lawyer or a person related to the lawyer. Let's just stop there. Now, why would you have to put that in there? And here's why. Because every year we have cases of lawyers who think they're going to get around this rule by having the client, instead of leaving the money directly to their lawyer, leaving it to the lawyer's kids, the lawyer's spouse. And so, by the way, that had to come later when lawyers were trying to find a loophole. They said, okay, now we got to add those in there. Unless the lawyer or other recipient of the gift is related to the client. Now, basically it says, okay, you can write your mother's will and still not have to write yourself out. We assume she loves you half as much as the other kids, so you don't have to write yourself out of that. If it's your mom, you can write her will. Keep going. For purposes of this paragraph, related persons include, and then they had to set the definitions. Why? Here's why. Because lawyers were saying, well, no. Yeah, I know we're not technically related, but she said I was like the grandson she never had. So technically that makes me a grandson, right? Can I still keep the money? And as a result, they had to lay out a specific list of people who would qualify. Because that's how ridiculous we've been in trying to cheat our way through this rule. And here we had a Virginia lawyer said did the same thing. The bar did not go for any of his excuses, had his license revoked, right? No more practicing law. Now he says, hey, I got $1.7 million, I could care less. But no, the family got that back too. So now you got no money and no law license. How about inheriting from your own parents? You gonna get 2 inheritances? That's wrong. Next nominee here. That was the movie Repo Man. Here we have a Michigan lawyer, gets a 30-day suspension for his efforts to avoid the repo man, or in this case, the IRS man, all right, Uncle Sam. The lawyer has tax indebtedness. The government wants their money, they levy his bank accounts, put liens on his property. And so now to avoid these levies, he is using the trust account, the client trust account, to pay all of his bills, personally, the office rent, everything. And as a result, he's got future payroll, right, in the client trust account. The money that's in the client trust account belongs to the clients, all right? And you pull it out as you earn it. You can't be putting money in there to try to hide from your creditors. Now, the weird part is, this is a reverse embezzlement, right? How bad could this be? It turns out you can get in just as much trouble for putting your money in the client trust account as you could from putting the client's money in your own pocket. Because remember, the rule here is that you must keep the funds separate. Not just that you can't steal them and do the transfer one way, but you can't do it the other way either. Certainly can't use the client trust account as a way to hide assets from others, right? To shield your indebtedness. That's not going to work. Now, that said, the winner, once again, the Academy is choosing the thing we think you're most likely to do. And believe it or not, it is the devil's due, to pay a fee out of the client trust account. I know this because I've gotten checks for my CLE programs from lawyers written from their trust account. It's always fun to hand that back to them at the break and be like, would you like me to report this to the bar, or would you like to give me a different check? I'm not losing my law license. I got to report you. All right. This is the kind of thing, though, that I think is important to remember, because this is an evidence in this case of simply a lawyer who had blatant disregard for the formalities. Right. I'm not going to be, he obviously had the money, but you're not going to be, he's basically pulling checks out, and whatever checkbook comes out is where he's writing the check. You got to really understand that they're very serious about that rule. And even if all the people get their money in the end, you have to follow every dot and tittle. And if you don't, it's going to be a problem. Certainly, if you don't show up, it's going to be a huge problem. Someone asked the question, if a client pays you in advance for work to be done on a specific project, must you put that money in the trust account and draw from it only when the work has been done and a bill has been rendered? I think so. And the answer is that's literally what the rule says. Go to 1.15, I believe in New York is going to be section C, maybe D, and it's going to say that almost exactly. That's exactly the process. Put the money in your client trust account, and as you draw it out, $250 at a time, or however you bill it out, then whenever you bill it out, you say, okay, I billed out $2,000 this month, then you pull that money out. All right. Until then, it's their money. All righty, let's move on. And good questions, by the way. All right, here we go. Best supporting actor in a criminal activity. Here are lawyers who want to go the extra mile to help their clients out. It turns out they end up going the extra green mile, so to speak, because in helping the clients out, or in attempting to, they don't really help themselves out. But our first nominee here is the movie Mudbound. And this movie is about some African-American soldiers, I believe, who come back after one of the wars and are not treated as well as they should have been when they try to establish farms in the South. But we actually, this movie isn't built out of nothing. Life imitates art, and oftentimes art definitely imitates life. And this was a situation that many people, African-Americans, experienced. And there's been a lawsuit, several lawsuits, and a settlement, and a program now that qualified minority and women farmers who were not treated well and given the benefits that others were given from the USDA are now entitled to $50,000 tax-free settlements. The program requires, some paperwork to be filled out. You can hire a lawyer, and the program will also pay your lawyer $1,500 in attorney's fees to do this for you. So the attorney's fees are covered up to $1,500. And this lawyer is approached by 4 sisters. And they say, hey, we heard about this program, and we know a lot of people who were, who are Black. And we like to get this $50,000. And I'm not sure we're all farmers or have ever been on a farm or know what a farm is, but you fill out the paperwork, I'll give you the names, and then you go ahead and kick back some of your $1,500 to us, but we can really get your practice humming. And sure enough, over the course of a couple of years, this lawyer processes $11.5 million of claims, or helps his clients to, on the basis that they were being discriminated against farmers. Some of them are 7. All right, it's not even like right, there's any way in the world. All right, he should have believed this. He's certainly filling out all of these affidavits on information and belief, and it turns out none of them are true. He's charged criminally for this. All right, at 75 years old, he ends up getting a probation because he's 75. But that's not how the bar saw it. And obviously, this is a lawyer who's going to be disbarred for his part in this scheme. The worst part is he's not even getting really any money out of this. $1,500 a pop. Certainly, he would try to argue, well, how am I supposed to know? And the answer is, it's not that you necessarily have to know. Sometimes your clients lie to you, but sometimes you should be a little suspicious. All right. And, especially, I've been to Little Rock. It's mostly metropolitan. All right. Not everybody has a farm in Little Rock. Almost nobody does, in fact. And so, to the extent that, you should know something is going on and you don't, you got a problem. All right. Ah, all righty. Interesting. I'm I'm going to put paste here, just if anyone's interested, the particulars of the New York rule with regard to trust accounting. I'm seeing here, and someone's posted this, and so maybe I've been wrong about this. I'm going to paste here in the chat window. If you want to take a look at your particular rules about trust accounting in New York, there you go. Thank you for the heads up, David. Let's move on though. Next nominee is the movie Payback. Here we have a prominent Delaware lawyer who is approached by a company. They want to start doing payday loans, or they're a payday lender. New York had passed legislation, Delaware passed legislation saying, hey, we're going to limit the interest rate you can charge to an effective 780%. You think anything over 790% is just greedy. So you got to be able to make a living on 780% interest. And they didn't want to. So they hired a big time, Delaware banking lawyer to go ahead and try to figure out a way to get through this. And he comes with an idea and says, wait a minute, native tribes, they don't have to be subject to these regulations for their banks. And so they start registering all these companies as Native American banks with really no basis other than the fact that this was his idea he came up with. Turns out that you can't do that. The lawyer, interestingly enough, is charged criminally himself. They charge him criminally and say, look, you are violating the usury laws. You're part of this conspiracy to violate the usury laws, et cetera. And we want you to go to jail. He pleads guilty. All right. So to get, try to reduce his punishment. Still, by the way, got 8 years out. And the bar says, well, we're going to have to come take your license now. He says, wait a minute. What did I do wrong? They said, well, here's what you did wrong. A lawyer should not counsel a client to engage or assist a client in conduct the lawyer knows is criminally fraudulent. And the lawyer said, I didn't know it was criminally fraudulent. I thought that we could do this. I tried, basically people come to me all the time to figure out how's the way we can technically comply with the law, but more the letter than the spirit. And this is my job. And they said, yeah, but here's the thing is, you knew you were wrong. He says, I didn't know I was wrong. He says, yeah, here's how we know you knew, because you pled guilty to the crime. And it was a knowledge crime. You said, I knowingly did this thing. Because I pled guilty, but that didn't mean I knew at the time. He said, well, no, that's not how this works. If you plead guilty to a crime and you allocute to it, then guess what? You knew. You don't get to tell us that you tell one court you did one thing and then tell the other court, no, I didn't mean that. And as a result, the lawyer ends up getting disbarred as well. Here is the movie A Score to Settle. And here we have one of your brethren, a New York lawyer, and he gets censured for trying to help a private high school quietly settle a very embarrassing and disturbing matter. One of the teachers has been sending inappropriate messages to one of the minor students, a young girl or young woman, or anyway, teenage girl. And as a result, the father finds out and is a father and comes to the school, says, look, these are the messages, it's inappropriate, et cetera. And not just, by the way, explicit messages, but, with images. The guy is not only creepy, this is illegal. And the lawyer for the school says, well, look, give me the laptop, we'll do our investigation. Now, to the school's credit, they fire the teacher immediately, but they don't want this to get to the news, and more importantly, to the other parents who are paying all this money. No one wants to pay $80,000 a year, but, have your child, harassed and hit on by teachers. And so they're trying to keep this hush hush. They go to the young woman and say, hey, look, we'll pay you a settlement. You're entitled to compensation for this. But part of that settlement is we need you not to cooperate with anyone, including the authorities, because we need to keep this on the QT. And that was a problem. That and it's interesting because it's a gray area. Oftentimes, one of the reasons that people want to have these out-of-court settlements, right, that for is to prevent, right, public disclosure, et cetera. But what you can't do is make it a condition that the person not cooperate with a law enforcement investigation, right? That becomes conduct that is prejudicial to the administration of justice, violation of Rule 8.4D, witness tampering. And you might not be charged for it. This lawyer wasn't. Sometimes, like I said, it's a gray area, but it's gonna be a problem in these situations. And like I said, particularly if part of the settlement is that they're not gonna get to cooperate. All right. All right, let's move on. Tales from the Crypt. Our last nominee in this category is a lawyer. And this, I believe, is one of our, yes. Every once in a while, we steal a case from Canada. Here we've got a Vancouver lawyer, and his client comes in and says, hey, I'm investing in this crypto stuff. And what I need you to do is be my lawyer and pay you a $5,000 retainer. And I want to use you to facilitate these transactions. I'll give you money. You then send it out to whoever I need you to. And sure enough, over the course of several months, he's deposited $2 million into the lawyer's client trust account. The lawyer, puts the money into escrow form and then sends it out to whomever. Now, interesting thing here is that there's nothing illegal necessarily about that in and of itself, but there was a question that the lawyer started to begin to ask himself, which is, why is this guy asking me to do this? You go to the bank fees are a lot less than $5,000 a month. The guy just paid me 10 grand last month as a bonus because I'm doing such a good job wiring the money. All right, come on, you could do that through Venmo. What's going on? He finds out that his client is not eligible to be able to use bank transfers. I think they have a social security number, whatever they use in Canada. And so in a sense, he's kind of helping this guy launder money that he otherwise couldn't transfer. And that's obviously going to be a problem. All right. If the person can't do it themselves, the fact that you facilitate doing it is going to be an issue. And particularly in this case, with regard to crypto, which, by the way, I'm just going to get right to the chase here, cut to the chase. And the crypto thing is the winner. It's the one that you're most likely to get wrapped up in. I'm going to say, with regard to all of these wonderful new types of financial instruments and arrangements, cryptocurrency and NFTs and BBDs and the East Coast family, whatever it is, all of this type of stuff. I saw recently Facebook real estate. Metaverse. You can literally buy real estate in the metaverse. And my understanding is Facebook stole about $500 million of metaverse real estate, which is literally blue sky. As you know, the securities laws were created so that, because there was concern, many states, right, that some point someone was going to sell people parcels of the blue sky and that people would buy them. And sure enough, some of this stuff is about as close to blue sky as possible. If you're buying real estate, digital real estate on a server somewhere, NFT, you don't even have exclusive control and access to it. When I buy the NFT for a certain image, it doesn't give me a copyright to it. You can still use it. That's almost like buying a parcel of the sky, and people can still fly through it. They can still breathe your sky. You just technically own that portion of the sky that you have no other incidents of ownership on. I'm going to say that to the extent that you are going to, if you want to lose your money in it, that's perfectly fine. All right. But to the extent that you are involved in transactions for others with some of these more interesting new creations, I want to say danger, Will Robinson, danger. We're going to see a bunch of cases in the future of lawyers that huge crypto bankruptcy that's going through now. There are going to be some Ethy awards out of that one. I promise you. There's some lawyers involved in everything. Always be careful. All right. That said, our next nominee is the AT&T Award. Now, we give this award every year to lawyers who fail to reach out and touch someone. The rule we're talking about here is Rule 1.4. And I want to say this. I'm just giving you a second to sort of look at it over yourself. Hopefully, it's not a new rule to you. You've gotten it. This is a rule that says thou shalt call the client backeth. This is the most important rule in the RPC. On my authority, which is none, but on my authority, you should take it to understand that I'm serious when I tell you, you should feel free to violate every other rule of the canon. You want to not do the work? Great. You want to steal the money? Wonderful. All right. You want to sleep with the client? Enjoy yourself. But you must call the next day. That's a rule in Dayton. It's certainly a rule in the bar. And I'm being 22% facetious. But here's the truth. Until you violate Rule 1.4, there is almost never a bar complaint. Why would anyone complain until you violated this rule? No client even knows the 1-800-DISCIPLINARY hotline number. There are, 600 lawyers here? And I bet you none of you know the State Bar Disciplinary Hotline number. You have no idea how to even report yourself. All right? You'd have to Google it. The client would have to Google it too. They don't even know this process exists. And they'll never know if you call them back. 90% of the time, the reason the clients call the bar is because they could not reach you first. All right? And I'm going to tell you, the easiest thing is to call the client back. Now, I should say that the simplest thing is to call the client back. It's not always easy. Oftentimes, we don't call back because we haven't done what we said we're going to do the last time. And that is where oftentimes the problem lies. But not calling back and hiding from that problem never makes it any better. All right. First nominee in this category is some of you recognize this scene, but you think it's from Home Alone 2. In Home Alone 2, what was his name? The little boy, Macaulay Culkin. He is trying to trick the people at the Palace Hotel in New York, or the Plaza, one of the two. And so I think it's Plaza. But anyway, what he does is that he has this movie playing in the background, and the guy says, "Get your no good keister off my property, or I'll start shooting you." And the guy pulls out a Tommy gun and starts shooting. And the people who hear this think that they're being shot at, and they scurry away because they don't know how TVs work. It's a weird thing. But the scene, the actual movie, I had to do my research. I'm prepared. Angels with an Even Filthier Souls is the name of the movie. Angels with Even Filthier Souls. And here we have a lawyer, an Arizona lawyer. He's hired to pursue a personal injury case on behalf of the client, right? Sends out a letter to the insurance company, and then, without any authority from the client, he settles the matter for measly $1,100. And then, worse than that, forges the client's name on the signature, deposits into his own personal account, and never gives the client any of the $1,100 that he shouldn't have ever settled for in the first place. When the client finds out, they're not happy. Right? And the lawyer, he reports him to the bar, and the lawyer says, "Okay, what do I need to do to make this right?" And the client says, "You need to obviously give me all my money." And the lawyer is so offended by this, he finally sends the client his money with a note that says, "Merry bleeping Christmas," which is what this guy said in the movie before shooting everybody, or after shooting everybody. Now, by the way, he didn't use bleeping. He used the real word. Here's the thing is, if you are going to talk to the client, you probably don't want to curse him out, all right? Especially after you stole from him, all right? But and I think that's what really kind of added some oomph to this guy's punishment. But he wouldn't have done well in any regard, because he had violated several rules even before he got to the bleeping Christmas part. It turns out that before you settle a case on a client's behalf, you actually have to get their permission. What a concept. And it's amazing. I'm finding this increasingly. Almost every year now, we're getting a lawyer who is settling cases and then coming back to the client afterwards and saying, hey, they're going to give us $400. Or you either take it or leave it. I just told them that if you don't take it, right, I'm going to tell them what you really did and you're going to get nothing. There's some lawyers who build a volume business, all right? Not taking any of these cases to court, but if I can get a quick settlement and run, that's not an unreasonable thing, but you certainly can't coerce the client into it. There's situations in which every case shouldn't be settled. All right, you get it. Our next nominee is the movie Bad Influence. And here we have a lawyer who was under a bad influence. We have an Ohio lawyer. One day coming to his office are an elderly woman and her adult daughter. They want to make sure that her husband, daddy, and the woman's daddy his affairs are in order. This is a very wealthy man. He's he's had a stroke 10 years ago. He's in a nursing home. They really want to make sure he doesn't have much time left. And so they say, okay, daddy wants to give this money, he wants to give this money here, he wants to give me this and give me that and give this and that person, etc. Here are his wishes. The lawyer never meets with the client at all. He takes their word for it, drafts up these documents, sends his paralegal out there and says, hey, just get a signature. And you know what? Just get an X if you can't sign. He's that sick. He can't, just signs an X. The lawyer has attested that he's seen the guy, signed the documents, et cetera, all these things which are not true. The lawyer had no part in this. Well, when the client dies, the will is contested, and it turns out that the other family relatives think that maybe the wife and daughter had taken advantage of the situation, that maybe they had been guilty of undue influence. They were bad influences here. They're definitely bad influence on the lawyer, because the lawyer ends up getting an 18-month suspension himself. Why? Because he had not ever consulted with the client, hadn't done any of the 1.4 stuff, hadn't ever met the client, had taken the word of the family members. How are you going to not trust a man's wife and adult daughter, right? That they are speaking for him and only what he really wants. Sure, they have several $1 million at stake themselves, but they wouldn't lie on daddy, right? I lied on my daddy for a lot less than several $1 million. All right, I lied on my daddy for about, this time of the month, about $3,500. All right, it maybe about $2,200 probably at the end of the month. All right, so yeah, people might do that. You have an obligation to actually check with the client, even if their spouse says, "Don't worry, don't bother him. He's good." No, you need to bother him. And you see here, one of your obligations is to reasonably consult with the client about the means by which the client's objectives are to be accomplished. Now, by the way, let's be clear. If the wife had a power of attorney, right? If he had given over control and authority to her, a conservatorship, a guardianship, then yes, you deal with that person. But to the extent that they don't have any legal authority over the person, to the extent possible, you need to deal with the actual principal. All right, next nominee here. Here's a movie, Don't Tell Mom the Babysitter's Dead. And here is a lawyer who didn't want to tell the clients that they were getting none of the money. And let me explain. This is one of those large consumer transactions, the kind of thing where, some lawyer gets an idea and talks to a client as a class representative and says, hey, when you go to Starbucks, they don't always give you your receipt, do they? Well, technically, according to this law that was passed in 1382, you're entitled to a receipt. If you don't get one, we should sue for damages, millions of dollars, and your portion is going to be about 38 cents. But my whole family's about to get rich on this one. That type of situation. It was a settlement, large class. The whole settlement was only for $700,000, and it turns out that the lawyers were going to get $390,000 of it. I'm sorry, that's wrong. They put in a demand for $700,000. The settlement amount was only $310,000, and the lawyers got $210,000 of that. So all these plans together were going to get $100,000. Now, what the lawyer did was that he realized they might balk if they saw that. So he didn't go to them and say, look, this is what the whole settlement is. he went to each individual and said, look, here is your money, here's your $22, here's your $17, et cetera, not disclosing to anyone what the lawyer's fees were going to be. And as a result, amazingly, that was a disbarable offense. Ouch. It turns out that you can't do that. Now, one of these things that's interesting here was that Taylor to Rule 1.8G. Remember, there's a specific rule for this, but this happens all the time. A lawyer who represents two or more clients should not participate in making an aggregate settlement of claims, et cetera, unless each client gives informed consent. The lawyer's disclosure shall include the existence and nature of all the claims and pleas involved and of the participation of each person in the settlement. So you're supposed to let everyone know what everyone else is getting. Sometimes it doesn't matter because it's just 32 cents a piece. We're all getting it. But then there needs to be informed consent, means that they need to know what you're getting too, so they can decide whether they're being screwed here, which these people were. The lawyer didn't do that. As a result, they now drive Uber, or more likely, they probably just moved to Florida. But you get the point. And then lastly, the movie Snatch and Grab. And here we have a Kansas lawyer who decided he was going to really communicate with the client. This isn't a failure of communication, but when you do communicate with the client, you want to be clear, direct, and you want to keep your hands to yourself. If you communicate with the client like this, that's going to be a problem. Particularly if they happen to be, I don't know, in court, handcuffed, and the bailiff has to come pull you off them. Then yeah, that's going to leave a mark. This lawyer got an 18-month suspension, some time to really think off and cool down a little bit. So when you do want to communicate fully, clearly with the client, but you're probably, like I said, you want to talk. You don't want to talk with your hands. All right, even if you happen to be, Black or Italian, or you might normally talk with your hands. It can't be this. All right, makes sense. Obvious, not obvious in Kansas. That said, here are nominees, and the recipient is, drum roll, The Bad Influence. The Bad Influence is a recipient here. Why? Because this is the kind of thing that happens a lot. If you do work with corporations, as I did, you almost never talk to the principal. And who knows who the principal even is, all right? But I can tell you that, years I did mergers and acquisition work, but the CEO seldomly called me directly, all right? Even the chief legal officer didn't usually call me. I got a call from the paralegal, said, hey, we're gonna cancel the merger. And I learned very quickly that before I just took, Steve's word for stuff, I'd want to confirm with somebody. and my strategy was always to play dumb, which, as you can tell, wouldn't be hard for me. And I would say, hey, you know what? It's an email to everybody. And when I say everybody, I mean, obviously, Steve, the chief legal officer, CEO, the CFO, EIO, EF Hutton, the butcher, the baker, the candlestick maker, everybody, the long recipient line. And I'd say, look, I went to public school. I don't hear that well, because I was bored a lot. I spent a lot of time sticking pencils in my ears. So I might have misheard Steve. What I think I heard is that we're going to cancel the merger. But just in case I'm wrong, I am going to put in the order for 459 to cancel the merger with Secretary of State. So if I'm wrong, tell me at least 458 so I can cancel this, because I don't always hear so well. And I'm exaggerating like 2%. But I'm encouraging you to confirm, all right, these orders, because Steve told me it's not going to be a good excuse, all right? Especially when you're dealing with married people. And this is an easy one, I can imagine, if you do bankruptcy work, et cetera. We had a lawyer in DC a few years ago, got in trouble because the wife came to him and said, hey, we need to file for divorce. I'm not divorce, we need to file for bankruptcy. My husband is in business troubles. It was, and by the way, it wasn't a hard bankruptcy. It wasn't one of the complicated ones. It was an easy one. Was it chapter 7, 11, 8 to hard way? It wasn't that hard. And so he gives her forms, hey, just have him fill out this stuff and I'll do the filing. She comes back, says, hey, here's everything. The lawyer had never talked to the client. And it turns out the husband didn't want to file for bankruptcy. He wants to file for divorce now, but the lawyer's got some filing to do too. Because it turns out if you file a bankruptcy petition for someone who doesn't even know they're being bankrupt, that leaves a mark. People get attitude about stuff like that. I don't know why, but they do. All righty. And by the way, thank you so much. All righty. Love these comments. All right, let's go. Someone was just saying, I'm psychic. All right. Somebody was just asking about this second code. I got you, boo. I got you. All right. ILS CLE 2. See how hard that was? All right. ILS CLE 2. Still says for the same thing. All right. I love Sean CLE 2. Okay. All righty. Sure, someone will still want that code put up, but you know what? I'm going to take a 4-second break while you memorize it, write it down, do whatever you need to. Let's go. Our next category, my favorite category, the Joan Rivers Award. This award we give every year to lawyers who do a Joan Rivers. And remember, Joan was known for, can we talk? Gossip, right? We have a rule here, 1.6, confidentiality of information. I'm going to do something that is going to be insulting to you. I'm going to read this rule to you. And I'm going to read it to you, not because I don't think you can read. All right? You're a group of lawyers. All right? Many of you went to public school, so probably 40% of you can't. I went to public school too, all right? But the point is that I'm going to read it to you because you are too smart to have ever read this rule yourself. And let me explain what I mean by this. Intelligent people do not read statutes and codes and rules verbatim, word for word. No. Intelligent people read headings. And then we skim the text of the rule and infer whatever was in the heading was in the rule. So as an intelligent person, you skim this rule to read, a lawyer should not reveal confidential information relating to the representation of a client. And that's not what it says. It says a lawyer should not reveal information, any information relating to the representation of the client, including the fact that they are your client, right? Unless the client says, please tell everybody my business, or you kind of have to, like you show up in court on their behalf. You can't be coy then, all right? But no part of that is because it would impress your boo. Yet, this is our first nominee of exactly that case. The movie here is Bedtime Stories. And here we have a Canadian lawyer. Again, wow, we got 2 Canadians. And this lawyer is a divorce lawyer. And as a result, his clients often have some juicy tales of infidelity and reasons why marriages broke down. All right, it's never because someone didn't leave the toilet seat up. It's some good stuff. And so he would tell his wife these stories. Now, interestingly enough, his wife didn't find these stories that interesting. And would always say, you know what, really, I don't think you should be telling me this stuff. But he just could not help himself, okay? Now, here's the thing about it is, yes, he's violated confidentiality, told his wife these stories. Why, all right, would this ever even get back to anybody? Did the wife call people and say, hey, that rash you have, did that ever clear up? My husband was telling me about it. No, of course not. The reason that we even know about this and it becomes a problem is that he's about as good with confidentiality as he is with marriage. So his current wife gets sick of him. And hell hath no fury, like a divorce lawyer's wife scorned. And she says, oh yeah, in addition to alimony, child support in this house, I'm also taking your law license. And she calls the bar and says, I've been to Sean's seminar. I know that there's a rule against this, and he violated it every Tuesday. And sure enough, right, this lawyer, all right, was held to account for, all right, pillow talk, all right, things he told his spouse. Now, this, by the way, is a speeding ticket of legal ethics, all right? Several of you have done that 4 times since this seminar started, all right? But I'm gonna remind you that the fact that you do it every Tuesday does not make it right, all right? Even though I know that's kind of how we bond with our spouses and tell them how our day went, you need to be using some hypotheticals and some just, client X. Because if they meet that client and say, ooh, that rash ever clear up, I will be making fun of you next year. And I will do it. I have no problem with it. Next nominee is the movie Dragnet. And remember, the line from Joe Friday is just the facts, ma'am. And when talking about your client, it's most important to just stay with the facts, ma'am. Here we have a lawyer who wanted to get out of the representation. Now, once a case, we get into court and all that, that you've got to go into court and get permission, right, from the court, leave of the court to withdraw from representation. The lawyer, in making his petition, writes in his motion, the client came to counsel's office in a rude and belligerent and absolutely uncooperative manner. He showed up with a woman he said was his girlfriend. Both were loud and unruly. The client declared that he did not require the services of counsel, and counsel agreed and told him it was his right to choose who represents him. Counsel then admonished him that whether he retains counsel or not, he must appear at all scheduled court meetings until this case concluded. He said he did not need any advice from counsel, collected his deposit, and left, and this counsel has not heard from him or seen him, nor do I expect to. The client has neither provided the information requested nor cooperated with counsel, me. All right. The client has failed to cooperate, making it doubly difficult, if not impossible, to prepare for defense. And according to the client, he does not need my services. So the hell with him. I threw in that last part. Now, this is not unreasonable, except for the part where he started out by going, my client, his trashy girlfriend came in here all rude and ignorant. I'm paraphrasing, but that's basically what he said. And believe it or not, he got admonished by the court. DC Court of Appeals said, hey, look, bro, I know they were pain in the butt, but you had to get all into the fact that his girl was all trashy. All right. All you had to say, all right, was that we had a difference of opinion. They don't want me anymore. I'm leaving. As the young kids would say less, playboy. All right. And this is an important reminder that when speaking to the court, you can reveal some, all right, client communication, some privilege, but it should be limited to the extent you need to get out. And he had good grounds to get out. See here, 4, the client insists upon taking action, which a lawyer considers repugnant or which a lawyer is a fundamental disagreement. The client fails to substantially fulfill an obligation. I'm going to recommend that what you do is actually, this is what you say. You literally use the word in the rule, right? Client has failed to substantially fulfill an obligation to the lawyer regarding lawyer services and is given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. All right. Unless the court asks you to elaborate, it's just the relevant facts. And the relevant fact here is I have a right to get out and I need to get away from this fool. Less details are better. Dude. I just answered that question. See, someone just asked, how do you do that? How about just quoting the rule? All righty. Now, once again, the court might ask for elaboration. In that case, you give them the elaboration, and the court can't come back and say, how dare you talk all this trash? You asked me to trash. So I was trying to be nice. That's how. All right. Dude, where's my cash? Or I'm sorry, where's my car? We have a DC lawyer, once again, and he decided that he was going to ask the question, opposing counsel, where's my cash? He settled the case on behalf of the client and then called and said, dude, where's my cash? The client had agreed, the defendant had agreed they're going to pay the lawyer's fees. Great. The lawyer hadn't had his fees. He decides he's going to ask, where's my cash? He doesn't call the other side, even their counsel, and says, hey, dude, where's my cash? No. He literally asked that question on Twitter. I'm not sure who on Twitter he thought was going to answer that question, but he writes, dude, where's my cash? Literally, right? Where's my cash? All right, puts the dollar sign on the S, the cash. And then, by the way, I love this part because, if you're going to put it on Twitter, why not? He tags then President Trump, First Lady Melania Trump, Senator Marsha Blackburn, I don't know what Marsha got to do with this, as well as ABC News, NBC, CBS, CNN, The Washington Post, Huffington Post, Postmaster General, Grandmaster Flash, and Melly Mel. I'm only exaggerating about 2 of those. That's too much to get $5,000, by the way. All right. But Trump doesn't deal with less than the 6,000. I know that. All right, personally, trust me. Seriously, this is ridiculous. But I could see about 17 of you doing it right now on Twitter. First of all, stay off Twitter, period. But secondly, that's not the place you handle your disputes. And then lastly, the movie Return to Sender. And here, we don't have time to get into all the details, but this is a potential nominee. Someone who it's been nominated by us, but might actually face bar sanction in the future, maybe. The Alex Jones's lawyer in the InfoWars cases. As you know, several of the families, the Sandy Hook families, have sued Alex Jones for defamation. He accused them of being crisis actors, and that this whole thing never happened. The Sandy Hook never happened. And so they've been going around the country in various jurisdictions, taking all of Alex Jones' money, taking several Alex Jones' money, because he doesn't have this kind of money, billion-dollar verdicts against him. In the Texas case, there was a disclosure issue. And the question is, does he know he's lying? And they said, okay, well, we think you have some text out there that you knew you were lying to people, and you turn it over. And he turned over some of the information, but not all of it. And there was another request, and the lawyer, Alex Jones' lawyer, inadvertently turned over some documents that Alex didn't know about, sent them to the other side, inadvertently, found out about it, and said, hey, send that stuff back to me. Now, I'm not going to get into the intricacies of the Texas snapback law, because if you send something inadvertently in Texas, you can kind of get it back, sort of, maybe under certain circumstances. But you sitting out in the first place is a breach of your ethical obligation, and likely going to be subject to some disciplinary action if anyone files a complaint about it. Alex probably isn't going to file a complaint, because the least of his issues now is his lawyer's law license, because he's got to try to figure out how to come up with about $27 billion by Friday. They want the money by Friday, all right? Or two, so he doesn't necessarily have an issue. The lawyer might not ever be charged here. I don't have a 2-month suspension to tell you about, but it is a good reminder of how careful you have to be, and the fact that, oops, send me that back is not necessarily going to be a good thing to fix it, despite whatever your state snapback law is. All right, now that said, the nominees here and the recipient, the one you're most likely to do, the one that you did 7 times already today, the one that I'm about to do right after this seminar. Bedtime stories. To tell your spouse something you weren't supposed to tell them because you trust them and they're your boo. And that would be good up until the point where they're no longer your boo and no longer like you. And then it might get a little ugly up in here for everybody. All right. Now that said, let's keep going through. I'm going to try to soldier through. This is where it gets complicated, people. And I'll tell you what the complication is that I always prepare. It's like the regular Academy Awards. This would be about a 7-hour program for all the stuff I've done. And none of us are going to stay here 7 hours. None of us are going to stay here past 2. All right, let's be honest. So I'm trying to now figure out what parts to cut and to when to give Beyonce to get her award. Do I just give it to her in the car in the parking lot, or do I make sure? And so what I'm going to do is I'm going to fast forward a little bit in the program. We're not even come back to it. So just know these were all very interesting and fascinating cases. But I want to get to my favorite category. I never do any program without talking about this particular rule. The rule you see on the screen here is the most important, not the most important rule, but it's my favorite rule in the canon. It's my favorite rule because I don't know, all right, if it is true. But the supposition behind this rule is so wonderful that I want it desperately to be true. The supposition behind this rule, this is the ABA model rule, is that lawyers are very sexy. The thought is that no rational person could ever be expected to resist our charms. We're so interesting, persuasive, and magnetic. Therefore, the bar had to put in place a bright line rule that protect the client from our sexiness. Because without this rule, every client is going to get all up on this. All right. And that's certainly, look at me, that's certainly true in my case. But I can't vouch for you. Your camera's off. But the premise behind this rule is that we're sexy. All right. And the clients, we need this rule to protect the client because they can't say no. Now, interestingly enough, I'm showing you the ABA model rule. Not every state has the rule. When the ABA model rules are passed, they're not done all or nothing. You don't have to accept everything or nothing. You can do it a la carte. As young kids would say, freestyle. You could take a little bit of this, take a little bit of that. And about a third of the states looked at this and thought, nah, we good. Well, we're not going to take this one. Now, New York is interesting here because you have taken a kind of a hybrid solution here, which is you should avoid it usually with regard to vulnerable clients, particularly matrimonial clients. Don't touch them at all. Keep your hands, all right, off the matrimonial divorce clients, all right, which is important. All right. New Jersey, on the other hand, across the Hudson, they're not as cute. You've seen these people. They don't have a rule. Policy of the Jersey State Bar is if you can get it, go for it. Now, please don't quote me on that. All right. That's not exactly true. I do a lot of CLE work in New Jersey. So I'm teasing a little bit. All right. About 33%. All right. I'm teasing. They're not exactly true. All right. But the bottom line is simply this, is that there's the other states, I call them the ugly states, they go by the general 1.7 conflict of interest provision, right? Don't represent the client if it's going to conflict with a personal interest of your own, as if you could possibly not, all right? But that said, here are lawyers who have had very bad love scenes, all right? First nominee is the movie Caged Heat. Most of the cases, almost all of these cases involve, I don't know how to say this, but let's just say it. Let's be honest. They involve men. This is the kind of guys, this is our thing. All right. This doesn't happen very often with the ladies, but we got a treat this year because every couple of years I get a case of a woman who can't keep her hands off us. Like I said, it doesn't happen often. And what normally happens is always strange to me. It happens in the context of caged heat. And what I mean by that is prisoners. Every couple of years, like I said, there's a case of a woman lawyer. And ladies, I partly get it. All right. I've seen Sons of Anarchy. I get the bad boy thing. All right. The long flowing hair, the Viking. Ladies, I kind of get it. All right. I do. It's good looking. I get it. But that's not, I don't know why that's a good strategy. Here we have a lawyer, once again, another Canadian, Toronto lawyer, 3 this year. And this lawyer goes to visit the client in jail. And I would like to explain to you what they did in the, what was the word for it? I was going to say in the hotel room, but it wasn't a hotel room. It was in the jailhouse there. There's a description here. I'm just going to leave for you to, in the notes, you can go look it up if you like to. I'm not going to, come on, we're keeping this PG. It wasn't even that bad. I don't know. There's a video, which of course I've not seen and I've looked for it a lot. But the point is though, I want to encourage you to wait till they get free. I assume if you wait another 25 years until they get out of prison, they probably won't be as hot as they were when they went in. But that's usually how 25 years works. So if you just do that, it probably helped most of the time. Like I said, I'm not sure what this is about, why this is the case, but it happens. We've had an Oklahoma lawyer a couple of years ago who broke her man out of jail, Bonnie and Clyde style. And the only reason we caught her is because, of course, she had to post a picture of them on Facebook. All right. If you don't put it on Facebook, it didn't happen. And so we caught her through Facebook. But I'm encouraging in most cases, just wait till they get out. All right, you be all right. Someone's asking, what about after the attorney-client relationship ends? I'm looking here, and the answer is yes. You can, if you wait until the relationship ends, you're going to be good. It better be all the way over, not just, well, the case is mostly settled. Well, I think I know what I'm going to do for the rest of the case, so we're good. Also, you can't do any more work for them, going forward, because that would be continuing relationship representation. So you might decide you'd rather have the money than the honey, all right? But do you, boo-boo, all right? But if you do it wrong, you're going to be in ethics, all right? Next nominee is Coyote Ugly. By the way, what an irony that none of the women in Coyote Ugly were remotely ugly. Even the coyotes were good looking, all right, in the movie, but just get past that. The point is that we have a rare case here of a Massachusetts lawyer. And this rare case of the lawyer gets caught sending inappropriate images, nude, selfies to the client. Now, that is not unusual. Sadly, that's happened every Tuesday. 7 of you have sent texts to people since I've been talking, and you're wrong for that. All right. And you should understand that there's a reason why when you send something through your iPhone, it goes whoosh. Because if you're sending that, that's what happens to your law career. All right, whoosh. But the case that what makes this case interesting, because we literally had 12 to choose from. But the reason this gets a nominee is because it actually involved a woman lawyer. This was the third such case I had, all right, in 12 years of doing the Ethy Awards, involving a woman lawyer getting caught for this particular transgression. And for the longest time, I thought that it was because women just had more sense than men. And you do, well, let's be clear. But that's not the only reason. It turns out, and I learned in this case why it's so rare for women to get caught in this behavior, is because it's hard for the client to tell. We have a case here of a lawyer and a client who meet originally not as lawyer and client. They meet on a dating site, and they're considering going on a date. They actually go on a date. And at the date, he decides he's not really that interested. And he says, hey, you're nice, and we have good times and talk. You're a lawyer. Matter of fact, there's work I could probably send your way, but no, we're not doing the other stuff. And she says, fine, send me to work my way. He starts working with her. And she says, yeah, but you probably still should, do the rest of this stuff too, and starts sending pictures, trying to entice him. And it's so unenticing that he calls the bar, which is amazing to me because I don't know how, as a man, you make that call. To the bar, hey, Doc, can you please stop telling my lawyer to send me pictures of herself? Hard call for a guy to make, but he makes it. Good for him. Not so good for her. She ends up getting suspended. I chose the term of the movie Cow Ugly prematurely. I hadn't done my research and Googled this particular lawyer. Let's be clear, just in case you know her, she's not Cow Ugly. I'm surprised he rejected her. But the point is, you probably don't want to send people pictures that are clients or even just anybody really. Anyway, but let's move on. The movie Fatal Attraction. Here we have an Ohio lawyer, and this lawyer gets a 2-year suspension for a fatal attraction with the client that goes very, very wrong. I'm sorry, he didn't start fatal attraction. Lawyers representing the client in her divorce. Then he starts having a relationship with the client. Before long, she's working in his law office. Before even longer, a little after that, he moves out of his marital home. And, by the way, he'd been telling her the whole time, we haven't been in love for years. What's the other one? We just staying together for tax purposes, for the kids, that type of stuff. And so he moves in with her. And then eventually, he's no better of a boyfriend than he was a husband. All right, that doesn't work out. He moves back in with his wife. And she says, I will not be ignored, and begins stalking both of them. At some point, he has to file a protective order against the mistress, which, by the way, can't make being at home fun at all. That's a lot of questions to answer. That can't be fun for anybody. All right. And at one point, they have a Glenn Close scene where she says, "I will not be ignored," and he has to say some things that really aren't appropriate, and it gets ugly. All right. As a result, he gets a 2-year suspension. This is normally how this works. And the thing that's interesting is that, very seldom are the lawyers in these situations, people are in situations where they fall in love with someone and the situation is right, where they can go forward and you know what, yeah, we met at work, but this will be a great long-term relationship. It's always some hanky-panky. All right. It's usually the fact that, he's married and not planning on doing any differently. And so now you have a situation where not only are you violating your professional obligations, but you're being kind of a jerk. All right. Because this person's already been through one bad relationship. You're getting involved in a relationship with them when you have no intention of doing, of having any fruitful long-term relationship with them. And you're just simply, victimizing someone who's already been victimized. It's not going to be sympathetic. And unlike 1993, you're not getting away with it. I use 1993 arbitrarily, before social media. All right. You would get away with it, these lies. But now, guess what? They're going to look you up on YouTube or on Facebook, on Instagram, all right? And they're gonna see you all hugged up, all right, with your boo, you know, the one you don't really love, but you just stay together for the tax purposes and the kids. And when they see that, they're gonna be mad. 70% of these complaints are from people who are mad because you lied. So even if you are cute and not being coercive, you're still gonna be wrong. And then lastly, the secret of my success. And here we have, in the movie, by the way, I love this, is by the way, good, it's an older movie, but it's good, all right? The young Michael J. Fox, that was a good Michael J. Fox. And he, in this movie, we're trying to work his way up, and he ended up sleeping with the boss's wife, which, by the way, worked out well for him at the end. It turned out to be, by the way, his step-aunt, it got weird, all right, don't get me wrong, it's a comedy, all right, it got weird. But the thing is, though, we have a lawyer here, Ohio lawyer, young lawyer, and the client says, hey, we got a client coming in, one of our big clients. She's getting a divorce. I need you to take care of her in this divorce case. Now, she's a big client, so I don't care what she asks, what she wanted to do. You make sure you make this woman happy. And he says, hey, I got you. I'm gonna do all the stuff, all right? And for a while, she's ecstatic, literally. The definition of ecstatic, but not forever. And what ends up happening is that at some point, she says to one of the other partners, "Hey, you know that the associate and I have been, you know, doing grown folk stuff, right?" And he says, "No, I didn't know that at all." And he brings him in and he says, "Are you crazy? This is our big client. You out here making honey when we make money? Are you mess this up? All right, now we all gotta go drive Uber, all right, and get part-time jobs at Starbucks, right, writing people's names on the cup because you, all right, can't, you know, keep the client happy. No, you gone." And they report him to the bar, fire him, etc. And you're gonna mess up, all right, somebody's beach house, all right, because you know you got the hots for the client. The thing that's interesting here, though, is that the lawyer gets in as much trouble for not the transgression, but guess what? It's the cover up, not the crime. Because when they came to him and said, "Hey, have you been sexing the client and sexing the client?" You know what his answer was? Of course, no. I did not have sex with that client. All right, Miss Lewinsky. We got the goods. We got receipts. We got your text here. Video, some OnlyFans page. What are you talking about? Not only does he lie to the bar, because when they haul him out there with security, he's still, "What are you talking about? It wasn't me. That's somebody else. Trick photography. They defake me." Well, he gets to the bar. They say, "Hey, your people told us you might have done some stuff. What'd you do?" You know what he said? "Nothing." Just like he was 6 years old. "I ain't do nothing." Yeah, he did more than nothing. He did all the somethings. And so it's a good reminder that in addition to not breaking the rule in the first place, you definitely can't lie about it. And we learned this in Watergate. Now, I know you don't think I was old enough for Watergate. Remember, black don't crack. Between us, I'm 238 years old. All right, I know, I've been around a long time. And trust me, it's always the cover up, all right? And very seldom the crime. And certainly in this case, Ms. Lawyer, I got 2 years to think about why you don't want to lie. And you're going to get caught. And here's the thing, guys, you are never going to be able to deny that you had sex with that woman, Miss Lewinsky, because in the history of ever, nobody has ever, I've never known a woman to lie about that. All right. Every time that the woman said that it happened. All right. That's how that always works. All right. No one's going to believe you. You got to come clean, which is why this is important. By the way, the recipient here was Coyote Ugly, only because that was hilarious to me. But let me tell you the more important lesson, the lesson I think we can probably sort of wind down on. The thing I'm going to leave you with, the most important part, is here's the watchword I want you to take from this program. Rules is rules. And I know that's bad grammar, but that's real good legal ethics. I'm going to say it again for you. Rules is rules. Here's what I mean by this. Oftentimes, we think of these rules as being a pain in the butt and sticklers, and we don't have to necessarily do all these things. As long as I'm not exploiting anybody, what's the harm? It's rules as rules. As I've gotten older and mostly whiter, in 55 years. Let me tell you something. My life has gotten so much easier as I've come to appreciate that rules is rules. I do a lot of these webinars now, and some of them are in, like today in New York, and I don't live in New York. I live in Arizona. Sometimes we do these things at 8 in the morning, New York time. That means I need to do it at 6 o'clock in the morning, Arizona time, which means I need to get into my studio here. I need to leave my house about 5 in the morning. If I leave my house at 5 in the morning, there's not a lot of traffic. I pretty much have the street to myself. And yet when I get to a light, guess what I do? I stop every time. I don't even look and then try to go through if there's nobody coming. I wait until it turns green. I sit there like a complete idiot by myself, 2 in the morning, 4 or 5 in the morning, right? At a light with nobody on the street but me. You know why? It's just easier. It's just easier to wait a minute and then go through when I'm supposed to. This is how this rule has to be. All right. You simply follow the rule because it's easier that way, because life is going to be so much easier for you, and you're not going to get in trouble because as smart as you think you are, and I know you think you're smart, I get it, I think I'm smart too, but you're not going to be smart enough. We had a case a couple of years ago here in my home state of Arizona. A lawyer goes out with a client. She says to him, the client says to him, "I'm digging you, boo." I'm paraphrasing, I wasn't there. But this, right? I like the cut of your jib, however that expression goes, and says, you know what? We should take this relationship to a whole nother level. He says, no, can't do that. Rules is rules. I've been to Sean's seminar. I know that you cannot do this. And here's what he does. He gets the next day, he comes back to his office, sends her an email, says, thanks so much. Enjoyed our time together last night. Here is the rule that says I can't because Sean said I can't do this. And then 9 days later, he calls her and says, you know what, girl? We grown folks. We don't need all these rules and stuff. We can handle this. And they start dating. Now, the first thing he does, and I got to appreciate and respect this, is he says, hey, let me borrow $10,000. And I like this because I would do this too. So if you're going to date somebody new, you want to make sure they're invested in the relationship. All right, they have some skin in the game now. So now she got $10,000 in a relationship. She can't just run off when she wants to. And now they start dating, and she finds out he's not quite worth $10,000. $6,200 maybe, but not $10,000, and says, you know what, I'm done with you. And now he gets reported to the bar, and it's all bad because he's borrowed money from her, and now everything is a problem. Why? Because he forgot, repeat it with me, we're gonna end on this. Rules is rules. What else is important is that I think it's 2 o'clock. So thanks so much, everyone. I've answered some questions. If you have any more, you can send them to me. I'll put in the chat window here my email address. Contact me, Sean@MesaCLE.com. But thanks so much, everyone, for everything. Hope you enjoyed yourself. I had a good time, and everybody take care.
I think everyone had a good time. Thank you so much, Sean. It was a great CLE. Lots of comments about people enjoying it. So thank you so much. This afternoon, I will resend everyone the affirmation evaluation and material just in case you don't have it. So stay tuned for that. And by next week, everyone should have their certificates. So thanks again and have a great afternoon, everyone.
Bye, everybody.